Hello and welcome back to Inside Update, a show brought to you by InsideInvestigator.org. We're a nonprofit newsroom using investigative journalism to root out corruption in the state of Connecticut. My name's Connor Dragotis. I'm the managing editor here, and today I'm joined again, back-to-back episodes with Alex Appel, because as I mentioned last time, she's cranking out these investigations, and this one is particularly complex, interesting, impacts everyone who will die someday. So something to think about. To my knowledge, that is all of us. So we should all have a good idea, or at least a better idea, about estate planning and some of the interplay of law internationally in Connecticut. And make sure that your language is right, I guess, is going to be the takeaway here. But Alex, how you doing today?
I'm doing great. Happy to be back. And yeah, except for maybe I think a few tech billionaires in California, this is for everyone.
Okay. Yeah, we aren't going to get into, I guess, the situations where we're creating, trusts or legacy type giving situations. This is for the rest of us who want to pass on what we have to the next generation. And one of the interesting things about that, I'm a former Series 6 and 63 financial planner guy, and I've had a lot of conversations with people about what they want. And I think the most important thing is that people have a genuine care for what happens next, right? I've found very few people who are like, all right, yeah, we'll just, all my money, someone responsible will figure this out. People want specific things to happen. And you dug into how that has gone sideways. This investigation is called Goodwill: How a Controversial Court Ruling Changed CT Estate Planning. Lead us off here.
Yeah. So first, what you said is correct. People who die with, it's not just money, although definitely money, but possessions, jewelry, houses, whatever, tend to have ideas of who they want to get it, how they want their relatives or loved ones to split it up. But the thing is not everything is so straightforward. So I'm not a lawyer, you're not a lawyer, and most people aren't lawyers. But there's this whole situation where if you write something that seems to make sense to a common person concerning something called survivorship or passing on your inheritance or your I'm going to start over. I'm sorry.
No, you're good.
No, so what happened is about around 2011, I believe, if I'm remembering off the top of my head, the Connecticut Supreme Court made this decision called the Rotolo decision about the phrasing of words in survivorship in wills. And so what that means is if you want to leave your estate to someone, you have to be really careful about how you word it. Because if you include something like survivor take all in a long list of people, that does not necessarily mean that the one surviving person gets everything in your estate. The heirs of the people who have passed before you, in this case, we're looking at the will of a woman who wanted to leave things to her siblings, they can get portions of your estate if you're not very careful with how you word things. And things that sound, like they make sense to you and me and anyone who speaks common English don't always translate in the legal sphere.
I appreciate you throwing out the disclaimer that we are not attorneys. I feel like that's always something that maybe I should just start every show with that, because we do deal with a lot of topics. And I think, our reporting team, especially the reporters, all have a bureau of attorneys who we, reach out to and consult with, because it's not just about, trying to provide these complex legal ideas to the public. It's also about simplifying them in a way that's fair and useful. I think that's something that could get lost in journalism if we aren't careful. Yeah, we could throw a ton of information at you, but if it's not actually useful and understandable, what are we doing? That's a really important part.
It's also about understanding them ourselves, because we can think we understand something, but again, I don't have any legal training.
Yeah. Well, in this, you did a good job, I guess, doing two things. So in the beginning, you're actually laying out what the will says. So I think you alluded to it or said it, but prior to uh, 2011-ish, this Rotolo decision, this will was written in 1974, and it was intended to say, hey, if these other siblings do pass, then it is just the remaining siblings that get a larger amount or a larger share because it would be decreased. But after this decision, that's just not the way that courts are interpreting it, or I guess is it? Walk me through a little bit in Connecticut. When someone passes away, they have a will. Whose job is it to actually take a look and decide what language means?
So it's a combination of people. First and foremost, it's the executor of the will, or someone who was designated by the person who wrote the will to handle their estate. In this case, for this woman, it was her lawyer who was the executor, and he wrote the will with her initially. Um, but if there is any ambiguity, people can challenge what will state. And in that case, you can maybe settle between two parties, or you can go to court and then judges decide. So what's happening in this particular instance is this woman, Janet Moultis, her executor, decided that based off this Rotolo decision, which ruled that, previous language like survivor take all, which occurs multiple times in her will, might just be generic placeholder language. They use the phrase boilerplate in a lot of court documents. And because of that, that's not a good enough reason to cut out potential inheritors of parts of her estate. So yeah, it really, and now her siblings are challenging it. So, in an ideal world, it's just the executor. But if you think something's unfair, a whole bunch of parties can go in, and then this can become a very long and drawn out legal process.
Likely expensive as well.
Very expensive. Yeah.
Well, let's talk about these siblings who are making these claims, because my understanding is this isn't an easy communication situation for them as well.
No. So first off, they don't live in this country. And then some of their nieces and nephews also don't live in this country. So right away you have this, forget even just time zones. Like they grew up, they lived in England. They have a completely different frame of reference for how the legal system works with inheritance. I don't know much about the English laws, but I know that they're very different than ours. So one of the issues is, I guess another thing to note is these are all senior citizens. They're all elderly. They have health conditions. One of them is on palliative care because cancer treatment didn't work out. And they have families of their own. And, their sister Janet has lived in the United States for decades. So while they kept in touch with her, it's not like, they're talking every day or seeing each other. And then you kind of have a few other complicated factors too, which are other relatives. So I spoke to 3 out of Janet's 4 surviving siblings. The 4th sibling traveled in and out of the country a lot more. So he had kind of his own relationship. And then also she had nieces and nephews, and they're younger. They travel. Some of them traveled more, some didn't. I did not speak to them, so I'm very careful with what I'm saying. But you have this family that's kind of scattered across 2 countries, 2 continents, 2 oceans, and they're all trying to come together during. Well, let's keep in mind too, she died when there were still a lot of COVID restrictions in place. So that's another hurdle to deal with. So everything is spread out. Very few people in the United States are familiar with our legal system, let alone from another country. And yeah, it's very difficult in many ways.
I think I lost you there for a second.
Yeah, if you said something, you cut out for a bit.
No. This is fascinating to me, and so help me understand too, because yes, they're separate. They're pulled across the world here, but this seems to hinge a lot on the attorney who helped write the will in the first place. did he claim that, hey, yeah, this was the intent, or is it the letter of the law that has to come into play here? I know that this is a tough question to ask, and I want you to explain why it's a tough question to answer as well.
Well, first off, I did not speak to him.
Yeah.
I was not able to get a hold of him. I tried many times, so I am functioning solely off of what, pardon me, Janet's siblings are telling me, and also what he wrote in legal documents that were, available on publicly available like court systems. So the biggest difficulty is I just don't. He did not give me his arguments.
Yeah.
But what it appears to be, and we quote the documents which are written in his own words in the story, is when Janet first died, he assumed for the portion of her will that was supposed to go towards her siblings that, what you and I probably would, when the phrase survivor take all was used, or survivors take all, that meant that only the surviving siblings get a portion of her inheritance, and the children of her deceased siblings do not. Well, sometime after the first court hearing, where they are hearing with the judge, hearing is the wrong word. I think that implies a trial. I should say meeting. Sometime after that first meeting, it seems like he changed his mind, because the judge, we didn't embed this, but I did listen to a portion of that meeting, and the judge answered, one of her siblings asked, okay, so is this just being split among the siblings? And the judge said yes. And sometime between then and a few months later, there was a change, and now her estate, or the portion that was allocated to her siblings, will now be split among her siblings and her nieces and nephews. And there was apparently a letter that was referred to multiple times that the executor wrote the judge. He did not share that with the family. And he didn't share it with us, obviously. We weren't speaking to him, or we weren't able to speak with him, and there weren't any records. So we saw his legal justification. He reviewed her will, and he decided that the phrase survivor take all was just kind of a holding phrase, and therefore could not be used to justify cutting out possible inheritors. But we don't really know what changed between his initial reading after she died and his rereading. And we also don't know what was happening in those conversations when she initially wrote that will, or when she updated it.
It's fascinating, truly. To have the same person on both sides of it, I think is doubly interesting, making the arguments and work out that clarification. A lot of this seems to hinge on that decision. And, I guess my question, a lot of wills were written before 2011 for people who are still alive. What's the best way to avoid having your estate not held up, from where you want it to go, but also drained financially through legal action? And, ultimately, I think we'd be hard pressed to find folks who wouldn't want these matters to be settled and allow these grieving processes to work themselves out without legal proceedings hanging over them. How can folks in Connecticut avoid that moving forward?
Talk to your lawyer. Talk to your lawyer. I know lawyer fees can be expensive, but you're saving money. Like, the money you spend now does not get taken out of your will later. So I guess I spoke a lot about survivorship and this idea of survivor take all, and that language is not sufficient to designate inheritors. What I didn't say is what language would be. So in theory, if I have two sisters, if I wanted to leave my books and I wrote, all of my books go to Emily and Caroline, survivor take all. Well, if they have kids, I have a niece. So if they have kids and one of them passes away, it's not like all of my books aren't just going to go to Caroline. Like, my niece is going to get a portion of the books I wanted to leave my sister. Unless I say, in the event that one of them passes, then et cetera, et cetera. So you need to explicitly, I would need to explicitly write my niece out of the will. I couldn't just say my surviving siblings get everything. I'd have to say my surviving siblings get everything. And if they pass away, their heirs, their inheritors do not get this portion of the will. And it seems very redundant, but this was a colonial era law back from when it was really hard to meet with lawyers, especially if you didn't live in cities. And so sorry, not colonial era. This is a early American era law. This is over, I think, 150 years old. And
I think you said it predates the Constitution, the Constitutional Convention by like 4 or 5 years, right?
Yeah, so I think we were literally operating under a different constitution in this country when this was written. It was like the Articles of Confederation. And this was created with, people had very different resources, very different lifestyles. So that's why this law is there, because if I wrote my will and I lived 200 years ago, let's pretend I could, own property, I guess. Actually, I shouldn't even say that. I'm not sure what the specific laws were at that time in Connecticut.
Your point stands, though.
Yeah.
I get it.
If I wrote my will and I didn't update it for 10 years, well, maybe in that time period, my other sister could have had a kid. And do I really want to be writing out, that portion of my family just because I couldn't meet with a lawyer or I forgot or a million other things were happening? So that's where this law comes from. Although this interpretation where these stipulations like survivor take all is more recent, the root of it is, it's hundreds of years old.
Language is such a funny thing like that. And I recognize the irony of saying that as two people who work at a newspaper, but, language changes, right? The meanings of words are going to change it, especially when they're locked in place by a legal ruling. That can make it that much more complicated or at least challenging to overcome, to have your wishes followed through on. Of course, all of what we're saying, Alex, not legal advice, right, about how to frame your will.
Please talk to your lawyer. Don't say, oh, well, two reporters from Inside or two employees for Inside Investigator told us this. Like, please talk to your lawyer. That is the best way. That is how you get what you want. And also make it clear to people in your life what you want as well. So if something does go wrong, they can step up and say, actually, I know X, I know Y, I know Z, I know what they wanted. This wasn't it. Writing, lawyers, people you trust.
It's very well said. And I think the only way that we are going to get involved in that is if you would like to leave in your will a bequest to Inside Investigator as a nonprofit. Then we might be able to help with some attorneys there to make things a little easier. We do have a legacy giving program, so that is an option on the table, as long as I can, just work that in naturally into the discussion here.
Oh, no, yeah, and it's very natural. If anyone wants to leave money to me in particular, too.
There you go. Exactly. The Alex Appel Fund is a subset there. Absolutely. Yes. This is a great investigation. Generally, I know, we talk so much about this journalism by humans for humans thing, and there's elements in here about what to do with the beloved cat of the deceased, and how to handle this property that is literally sitting there gathering dust. There's some really interesting other elements in there. I would encourage people to read and check out. Joe did some funky stuff with the visual designs on this one that I think at least draw out the emotional element of the confusion that is unfolding. And it seems like you got to meet with some cool people as well, which I always appreciate in the work process. Anything else that you want people to understand about this other than go and read the darn thing?
I just think the only other thing is the law is very complicated. We've said that a million times. There are good reasons that a lot of these laws exist, or a lot of these regulations, I should say. Like, there are good reasons why one of the things that comes up with the House is the siblings had a very hard time seeing it, and they had to work through the executor. There are good reasons for that regulation. It's just a matter of, are the people responsible acting responsibly? So there's a lot of things that, stand out as odd, but they exist in a larger context. And it has a lot of these issues have less to do with the laws themselves and more to do with how people in positions of power exercise that power and interpret them. So just kind of keep that in mind, have an open mind, because there are some things that came up to me in the reporting process. I was like, why in the world would this not be allowed? And in fact, there is a good reason. Like, why would this language not be sufficient? There is a good reason for a lot, like, or maybe not a good reason. Maybe you can disagree if it's good or bad, but like there were reasons that go into these decisions. But yeah, and with the Rotolo decision, like there was a court decision. It was a thought out but very controversial decision. So, it's not like this is a just keep in mind the complexity of the laws and keep in mind that, some of these things really do, at least to me, sounded really crazy, but like they are rooted in rational concerns a lot of the time.
It's a good point, especially given our mission to root out corruption, right?
Yeah.
You hope that there are mechanisms in place that prevent fraud and violence and all these, frankly, just outright self-dealing, which we know it would take multiple hands to count up all of the tips we receive about the way that estates are dealt with. And I think that that's something that I want to make sure that people are aware of is we are keeping a close eye on this. We have received tips about property being stolen,
Yeah.
about improper self-dealing, about corruption at the highest levels of Connecticut state government. That, to your point, who's watching the watchers, right? And frankly, it's us. That's one of the reasons why we're here. So if you have experienced something, if you are aware of a situation that has unfolded where a state has been taken advantage of, and again, theft, violence, harm done, please don't hesitate to reach out. It's a project that I think is ambitious, but we're working on it, and I think it's something that you can expect to see more of in the future, likely from Alex, as she has already taken the bold step of learning some of the legalese here. I think that uniquely sets you up to be that person. So you can reach her at alex@insideinvestigator.org. But as always, with all tips, you can send those over to tips, TIPS, at insideinvestigator.org, where we will be happy to receive them. Alex, thank you for this investigation. Thank you for all your work. You have put out a host of other news stories since this came out, a bunch of other content, all of which is available at insideinvestigator.org. And I will just make a brief pitch saying, even if you don't plan to include Inside Investigator in your will, we would still love to have you as a donor. As little as $5 a month goes a long way toward helping us build a sustainable nonprofit to continue the work of rooting out corruption in the state of Connecticut through investigative journalism and serving people with white glove service in every single way that we can in pursuit of our mission. Thank you again, Alex. Thank you to everyone tuning in, watching, listening, and catching this in all kinds of different places it's distributed. We'll be back in 2 weeks, and until then, be well, stay safe, and stay informed.